Okay, well, we're going to go ahead and start with the people we have. And what I want to do today is go over the statute, the law in the state of Virginia as far as disclosure, what agents have to disclose, what sellers do and do not have to disclose. So I did not have them download the law for you. I'm just going to go through the law and then we'll look at the forms that we did have you download. Nestor is working with me on Dropbox. So I can bring these documents up, but we ran into some glitches today, so we'll just do it the old-fashioned way, and maybe next time I'll be able to put stuff up on the screen for you. So when it comes to property condition and agent disclosure, licensees must treat all prospective buyers and sellers honestly and not knowingly give them false information. What does not knowingly give them false information mean? Well, in our statute, it says, I have the right to believe my client if my client tells me something, unless it's obvious that they are lying. So if I tell you I put a new roof on my house, it looks like a new roof, I have the right to rely upon that. And if I tell the purchaser that there's a new roof and turns out that the roof leaks, well, that's, we didn't know that, so we wouldn't be responsible. So honest and not knowingly give false information. Now, the law says real estate agents have to disclose material adverse facts. So if you are representing a seller, okay, you're representing the seller, you must disclose in a timely manner to a prospective buyer all material adverse facts pertaining to the physical condition of the property, which are actually known by the licensee. I know there's a lawsuit going on now where the builder permit didn't have the right permits or something or another, and they're going after the agent. Well, I don't think the agent has a problem because it's not a known material adverse fact about the physical structure. Now, if it was their buyer's agent they were going after, I might rule differently. This disclosure must be made in writing to any prospective buyer and or buyer's agent. This disclosure should not be included on the or written into the seller's residential disclosure form. We're going to look at that form in a minute. That form has to be filled out by the seller. Your handwriting should never be on there, and you don't disclose anything on the seller's disclosure form. That is simply an information form that says, go to this site for my disclosure. So never put anything additional on those forms, okay? Now, material adverse facts, okay? Material means that there's something physically wrong with the property. Adverse, if the buyer knew of that fact and they would not buy the house, then that's adverse, okay? Material adverse fact, not defect. A lot of agents think it's a defect. So in the instance I'm often asked about polybutylene pipe. It's not leaking right now, so that's not a known material adverse defect. But if you were a buyer and you knew a house had polybutylene pipe, if you wouldn't buy it, then that's a known material adverse fact about the physical structure and the property. As an agent, I'm going to be disclosing, okay? So don't get it confused between defect and a fact. A case I use in a lot of my classes. The seller has repaired their roof 7 times already this year, 7 times. It's not leaking right now, but it's already leaked 7 times this year. So if you were putting that property on the market, would you disclose that this roof had been repaired 7 times? Or since it's not leaking, don't worry about it? Well, if a buyer knew that there'd already been 7 repairs to that roof, do you think they would still buy that property without asking for some kind of a credit or a new roof? If your answer to yourself is no, they wouldn't, then that's a known material adverse fact. Okay, so don't confuse it with defect. Now, A licensee must disclose in a timely manner to their own client all material adverse facts related to the property or concerning the transaction. Okay, so to your client is not only tell them of defects in the property, so if you're representing the buyer, but anything else that you know of that would affect the transaction. Okay, but the key to it is you have to actually know. If you didn't know, it's not a problem. So there's a difference between disclosure of a seller's property, what's required by an agent, known material adverse facts, and to your client, that's known material adverse facts and anything else that would affect the transaction. Okay, and there's one thing was added to our disclosure, and that is defective drywall. We will talk about the 5 mandatory disclosures the seller has to make in Virginia, but defective drywall is one of those, but it's also been added as a duty that we have to disclose. So if a licensee has actual knowledge of the existence of defective drywall in a residential property, and it's residential, right, that has not been remediated, the licensee must disclose that to a prospective buyer. And our duty to disclose is in writing. So anytime you know of any known material adverse fact, it must be disclosed in writing to the other side, okay? So the defective drywall is one that we also have. Stigmatized properties. Stigmatized properties. And if you really want to check in on this stuff, if you go to our code in Virginia, section 54.1, 21, 31, and in that area, you'll find all these duties. Stigmatized property. So we don't have a duty to disclose stigmatized properties. So that what is that? Well, it's an act or an occurrence which had no effect on the physical structure of the property, its physical environment, or the structures located on the property. And the ones that are specifically listed in our statute: suspected haunting, homicide, felony, or suicide. So do you have to disclose a murder took place in a property? Maybe and maybe not. The murder itself, no. But what if, as a result of that murder, the hardwood floors were blood-stained, the owner, and it was never cleaned up in accordance with health regulations, and there was just a piece of carpet put over. If you know of that blood stain, well, that's still a known material adverse fact. The murder, no, but that blood stain, because most purchasers probably would not want to buy a property with those blood stains. Well, most of them don't want to buy if there was a murder in a property, but we have been relieved of that duty. Now, very important to remember, you can't disclose those items if you're representing a seller without the seller's written permission. Don't disclose them without the seller's written permission. So if you feel like you have to disclose, they won't give you permission in writing, do not take the listing. Okay? And if you have any questions as we go through, just yell out. All right. And the reason I'm doing it this way today is because I've had several instances in the last couple of weeks where if people knew what the statute said, we probably would have not even had to have a discussion. Seller disclosure. What does a seller have to disclose in Virginia? Not too much. We're a caveat emptor state. Remember that. Buyer beware. Seller doesn't have to tell you about things wrong with their property except for the 5 mandatory ones that we will discuss. So why ask an owner to tell you about their property when they really don't have to tell you too much about anything? Now, the flip of that is they can't hide it. So if they cover it up so you can't find it, they're not going to be covered by caveat emptor. So the Virginia Residential Property Disclosure Act applies to all transfers, not just ones that are listed. So even a for sale by owner has to use the disclosure form in Virginia. Okay, the disclosure made pursuant to the act, it's a seller disclosure. It's not a license, not you, okay? Once again, your handwriting, anything should not be on that form anywhere. This is something that should be prepared by the seller, okay? What is your duties under this Residential Property Disclosure Act? You know, when this first came out, you know, we really had a lot of input into this as an industry to try to protect ourselves. So a licensee representing a seller as a listing broker, you have a duty to inform the seller of their rights and obligations under this act, okay? And if you explain the rights and benefits and obligations under the Residential Property Disclosure Act, you've met all your requirements, okay? You're not guaranteeing anything at that point. If the buyer does not have a buyer's agent, so you are selling one of your own listings to a customer, then you have that obligation also to inform the unrepresented buyer by law of their rights under the Residential Property Disclosure Act. And if you're a buyer's agent, you have the duty to explain the rights and benefits and obligations to your buyer client. So if you perform your duty, you have no further obligation under the act. So, you know, we insisted that be in there when this act was drafted. In the summary of the rights and obligations form, which I had them include, I think, in this package today, we'll take a look at it. There is a form. Matter of fact, if you can find it in your package now, I believe we added it in it. Okay, it's called the Understanding Your Rights and Responsibilities. Okay, understanding your rights and responsibilities under the act. This form is an excellent form. You should be using it. I know you may not, but you should be using it, okay? It's not something that's attached to the contract. It is a disclosure form that would be prima facie evidence, especially if you get the additional form signed that is an acknowledgement. If not, at least get them to initial. If you go through this with them, you have covered everything we're talking about today, and it's prima facie evidence that you have done what the act said. You have gone over it with the people and they understand. So we will be taking a look at that as we close today. Okay? Any questions about that? Please start using that form if you haven't. Okay, and it's on NVAR's website, and it's form K1346. So if you go into the NVAR site, you can download all these forms by using those form numbers. Okay. So I love that summary. I use it with all my transactions.
Larry, what form? It's a K1346, you said?
Yes, it's called Form K1346 in NVAR's website. And it's called Understanding Your Rights and Responsibilities under the Virginia Residential Disclosure Act. Okay, and it's an excellent form. It covers everything that we're discussing here today. All the 12 I don't have to tell you, the 5 I do have to tell you, etc. So it's an excellent form to be using. Jocelyn, did we include that in our forms for today?
No, we didn't. That was the one you emailed me yesterday?
Yeah.
No, it was too late.
Okay. Yeah, I didn't think about it until then. So K1346, and I'll briefly go through it. Or while we're doing this, if you want to go online to NVAR, you can download it yourself. Okay. Poor Jocelyn, I dumped stuff on her at the last minute, you know, so I apologize for that, Jocelyn. Okay, so timing of these disclosures. When do disclosures have to be made under the Residential Property Disclosure Act? Under the law, the owner of the residential real property must provide the purchaser the seller must provide the purchaser with this residential disclosure statement prior to the ratification of the real estate purchase contract. So before the contract is signed, they need this form. We generally try to download it into the Bright MLS, but that doesn't mean they got it. So as a listing agent, one of the things you need to make sure you look for is that this form is signed by the buyer and submitted with the contract, okay? They have to receive it before contract ratification and acknowledge it. Johanna said to get some incomplete contract packages. And you're not going to get paid until you turn everything in. So the agent should know what has to be turned in. I still use a contract folder that I buy from Northern Virginia Association of Realtors. That's a processing folder. It has everything in the contract that is necessary from the start to the finish, when things were ordered, when they were delivered, everything you possibly need. I actually have a couple of them on top of my bookcase in the office there, Jocelyn, if anybody wants, if you want to find it and make a copy of it so they know what needs to go in the folders, because you got a checklist. Okay, so what happens if the disclosure is delivered after ratification? Well, this is paragraph 7 of your sales contract, and I realize it's boilerplate. But if the purchaser has not received those documents and acknowledged this form that we're going to look at, then the purchaser has the right to void the contract 3 days after they receive the document. So I'm not saying this would ever happen, but what if a buyer's agent purposely did not send that document over and you don't catch it as a listing agent? And then they get turned down for their financing, et cetera. And then all of a sudden they say, well, you know what? We never received the form. And you're telling me my buyer's in default. And I said, we never received that disclosure form. Could you send it over? And once you send it over, within 3 days, you get a notice voiding your contract. So make sure it's in your package, because they have the right 3 days after hand delivered, 5 days after postmark, or if it's a pre-occupancy, et cetera, you can read that part, okay? And there's one other part of the law that not too many people pay attention to. At or before settlement, the owner is required to disclose any material change in the disclosures made relative to the property. So if something major happened or anything that affects the property, technically the owner is supposed to give a written notice to the buyer of that change. So it's called change in circumstances. Now, we have a form. I know you got this one, residential property disclosure statement, okay? Residential property disclosure statement. At the bottom, it would say a D4 form, okay? And you're familiar with this one. You know this one has to be done by the seller, and it's seller form to fill out, okay? And it's an acknowledgement. The owner of certain residential property, whenever the property is to be sold or leased with an option to buy, provide notification of any disclosures required by the Act, and it refers them to the email address for DPOR for the site where these disclosures are contained, okay? And all parties have to sign it, and prior to our ratification of the contract. So once they go to that site, and make sure they go, you may even want to, if you use that summary of rights, it lists all the things that I'm going to talk about real quickly here. But this is what your buyer would see when they go to that site. So you need to make sure they go. There's actually an additional form acknowledging that they were informed to go to the site that DPOR is putting up because it's required by law. Buyer beware statements. So when they go to the site, they expect to find, the seller's disclosures. Well, what does that mean? Well, the first 12 items are things I'm telling you you really should check out. I'm not telling you I have it or not, okay? So real quickly, it's the condition of property or any structures or any recorded covenants or restrictions, any matters pertaining to parcels outside, including zoning outside of my property or permitted uses, a historic district ordinance, Chesapeake Bay Preservation Act, presence of any registered sex offenders in the surrounding area, a dam break zone, stormwater detention facilities, wastewater system, the right to install solar panels or devices, whether properties in a special flood hazard area, or any conservation or other easements, and whether it's subject to community development authority. So they're put on notice. Even if the owner has those, they're not going to tell you. You need to check them out, okay? So the disclosure statement advises buyers that the seller is making no disclosures with respect to those. But on that same site, there are five that the seller has to tell. They're called affirmative disclosures, okay? Affirmative, and it is a seller disclosure. It is not our disclosure. So you really should be going over these things with the seller. The first one is military air installation, okay? Now these are all DPOR forms. You can find these on NVAR site. They don't have an NVAR number, but there is a section on that site that says DPOR disclosures. The first one is military air installation, okay? We don't need this one in Northern Virginia, but I do know there's some agents that go outside of Northern Virginia in our company to sell property. And if you get into one of those areas, like down in the Norfolk area, et cetera, you would need this disclosure of near a military installation, and it's about noise zone and chance of a, hazard crash or something another. So I'm not going to spend any time on that. Just be aware that the owner has to disclose if they're in one of those zones, right? Defective drywall. If the owner have a residential, and once again, residential dwelling unit has actual knowledge, not that they have it, they have to actually know they have defective drywall in that dwelling unit, then they have to use this one-page disclosure form called defective drywall disclosure. If you pull that one out that they sent to you, this is pretty straightforward. If you have actual knowledge that it contains defective drywall, provide written disclosure of that fact to the purchaser. And these forms are all in addition to that one-page mandatory one that we need signed no matter what. What I like about this particular form is at the bottom, it defines what defective drywall means. And that's drywall that basically came from China that contained elemental sulfur exceeding 10 parts. I'm sure you don't care about that, but what you really need to care about is between 2004 and 2007. So if you were listing a house built between 2004 and maybe 2008, they might very well have some of this defective drywall, okay? So that would be a tip off that you might want to ask that question and go over this form, especially if you're in a house at that time frame. I just use all these forms in my listing presentation and simply say, hey, we need to go over these 5 forms just in case. And that just shows that you know a little bit more than other agents. The next one, and this was an important one because this is the one that most of the cases that I get called on is based on. Pending building or zoning violations. If the owner has actual knowledge of any pending enforcement action under the Uniform Statewide Building Code, they've actually been given a written notice that they're in violation of the code that affect the safe, decent, sanitary living conditions of the property, received a written notification of any pending violation of the local zoning ordinance also that has not been remedied within a time period set out in the notice, then you have to use the disclosure form. Let's read this disclosure form together, okay? The Code of Virginia requires the owner of residential real property who has actual knowledge of one, any pending enforcement action pursuant to the Uniform Statewide Building Code that affects safe, decent, sanitary living conditions of the property of which the owner has been notified in writing by the locality. And that's the key, in writing, right? Or any pending violation of the local zoning ordinance that the violator has not abated or remedied under the zoning ordinance within a time period set out in a written notice of violation for the locality or established by court competent jurisdiction. So if I'm looking at the tax records and it shows a completely unfinished basement, I'm in your home and the basement's completely finished. There's a bathroom, there's a bar with a big sink and a kitchen, and you get the idea. And I should be asking those people, did you have permits for all this? Because first of all, the bar is illegal because of the size of the sink, but all the other plumbing and electric, I need to know if they actually had a permit. But even worse, you're the buyer's agent and you're in this finished basement. And your buyer writes a contract on this property and you don't catch that this has been done without permits. Once your buyer settles on the property, unless that seller had actually received a written notice of a violation of installing that finished basement without a permit, your buyer is going to be responsible for it from the day of settlement on. And in paragraph 20 of our sales contract, it addresses this. It says they removed the word requirements. It was a requirement that I had to have a permit, because unless I've had an actual notice of violation and I get away with it, the problem moves on to the next person. Okay, somebody have a question? I can't hear. I cannot hear whoever's asking a question. I cannot hear you. Johanna or someone, did y'all hear that question? Because it's not, I hear somebody asking, but it's not coming through.
No, probably she hasn't unmuted, or who's the one asking the question?
I don't know. It just showed I heard somebody asking a question and it didn't show here on mine. Okay, well, if they can get. All right, well, when we figure out how to hear them, we'll go with it, okay? The next one up is meth labs, okay? The meth lab. If the owner has actual knowledge his or her property was previously used to manufacture methamphetamine and not been cleaned up in accordance with the guidelines established by law, then they need to use the next form we have, which is the disclosure statement for residential property previously used to manufacture meth. So if it hasn't been cleaned up in accordance with the state guidelines, use this. If someone tells you their property was used as a meth lab and has not been cleaned up in accordance with statute, then I probably would get out of there and not take that listing. Okay.
Larry.
Yes.
Hi, this is Nahid. Hello, everyone. Larry, if the seller does not disclose that he has finished the basement on the form property disclosure statement, then whose fault is it?
Well, it would be their fault too if they did not disclose, but it's only if they had received a written notice. So say they finished their basement without a permit, and for some reason the county found out and they sent them a written notice that you finished this without permits, contact us. Now they've received written notice, they would have to use the form. If they have never received a written notice, then they're off the hook. Okay.
Mhm.
But if I'm a buyer's agent and before they write a contract, I always pull the tax records. I want to see everything I can about that property. I Google the property address to find out everything I can. And it shows it's an unfinished basement in the tax records, and you showed it and it's finished. Then I'm going to put my buyer on notice to say, hey, look, you better protect yourself here. It shows this is an unfinished basement. I would suggest we write in our contract that the seller has to supply to us the records, okay, that they've had permits and been finalized. At a minimum, I've discussed this before in the past, but at a minimum, like in Fairfax County, go to FIDO. If you Google FIDO in your computer, Fairfax Inspection Database Operation, and you put the property address in, it will show you if they've done any work to that house and if they've pulled the permits and if they've been final. And every county has this on their systems now. I think the default in Fairfax County is 5 years. You could change it to go further back. So if I'm going out on a listing appointment, I want to know what's been done, because we don't want a problem coming up later, because even the appraiser may pull it. I think a really good home inspector pulls all these reports from the county to see if anything was done, so they know things to look out for. So, but unless they've received an actual written notice, then there's nothing for them to disclose.
Mhm.
You just-
So in
you
case
just wanna
in case the agent doesn't get the chance to report all of this or get this information from the county and report it to the buyer, so eventually it will surface.
Yeah, and if it's after settlement and there was no written notice of violation, then the new buyer is going to have it. So if you have a buyer client that now needs a permit for a new gas hot water heater to be put in their basement, and that inspector comes out and finds that completely finished basement when it's supposed to be unfinished, if they go back to the county and report that, then your buyer, after settlement, is going to get a notice that they're in violation and they need to come up and correct this. And so they tell them, take out the permit, go home, take your walls down from your, so we can see the plumbing and electric. They're going to be kind of upset. And then they're going to be coming back to you saying, hey, the seller didn't tell us that. Well, the seller didn't have to tell them that because they had never received a written notice. So just protect yourself, realize it's out there. If you have a property where there's been an actual notice, and it's one of the things you actually need to ask the seller now, right?
Right.
And that's why I go through these forms. Have you received any kind of a notice? Because they may not voluntarily tell you. Okay?
Mm-hmm. So what will the effect would be on the settlement date?
Well, if there was this, well, it won't show up in the title search. Okay. So, if the seller did not disclose, I think afterwards, then the buyer would be able to go back and sue them if they had received a written notice of a violation.
Mm-hmm.
Okay.
So the buyer wouldn't sue the agent, but they sue
Well, I wouldn't say that. They try to sue everybody at that point. But it's not something that we have to disclose. But think about this now: if you're the agent and you know this basement was finished without a permit, now did they just put drywall up? All the plumbing and electric was already in and approved when they bought the house. It was just a roughed-in basement, not finished, and all they did was put drywall up. Then that doesn't require a permit. But if they do anything with plumbing, electric, gas, any of that, that requires a permit. Anytime you touch any of that stuff in your house, it requires a permit. So if you know that basement was finished without, I'm going to be asking to protect myself. And it's a judgment call. I've had a lot of buyers say, well, we'll take the gamble. It's, we want this house badly. We're not going to make the seller do it. Well, get something in writing to protect yourself. Remember last week we went over that new form that that NVAR put out to deal with, I believe I've got it laying here, deal with buyer's acknowledgement of potential adverse consequences.
Mhm.
If you have that situation, then I would use K 1308, where they're waiving home inspections, financing whatever they're doing. I would use that form as a disclosure to protect myself. It's not something that gets included in the contract, just something to have in your file that says, look, we acknowledge this, we've made the decision to move forward, because we really want this property.
Mhm.
And that's a big problem. I mean, how many people finish the basements without permits? Probably most of them.
Well, I know some people do. I know at least one or two.
Yeah, I know. And it will come back later and maybe haunt everybody.
Yeah.
Okay.
Mhm.
And that's part of the reason I'm going over all these forms and all today, so that people know, hey, there are actual one-page disclosure forms required. Now, these are required forms, okay? By law, these are not optional forms for a seller. Even though we're a caveat emptor state, that website, when the buyer goes to that website to check out my disclosures, we have the 12 I'm not telling you, but they have these 5 mandatory disclosures by a seller. And these are the forms that are put out that have to be used.
Mhm.
Okay?
Thank you, Larry.
Good. Okay, so there's another form, disclosure statement for certain new dwellings to be used especially if you're dealing with a smaller builder. It requires the builder of a new dwelling to disclose in writing to prospective purchaser all known material defects which would constitute a violation of any applicable building code, but only if they have that, or if you're in District 15, if it's in a mining area. Hopefully none of our people are going into District 15, wherever that is, but must be in Southwest where there's a lot of mining. Okay. Another form that is optional, okay, this one is optional, and that is called a tourism activity zone. I don't have the form here. But if you have a purchaser of a property located partially or wholly within a designated tourism activity zone, there's a form that you can use just so everybody's on the same page. I think probably City of Alexandria would be an example of this, where, there's special events, parades, temporary street closures, indoor, outdoor entertainment activities. It's not a mandatory form. But you can get it from DPOR site if the owner wants to voluntarily disclose it. Okay. Now, one more form. It's called disclosure regarding validity of septic system operating permit. If your seller has received a waiver because their septic system needs repair or has failed, and the county has given them permission to stay in the property, okay, they have actually received, this waiver in writing. It will be recorded in the property records, so it's going to show up at settlement. And if they have that waiver, they have to use the septic system operating permit waiver disclosure. And it says property is presently subject to certain repair and or maintenance requirements. Owner has obtained a valid waiver of such requirements from the board. That waiver is not transferable and shall be null and void upon settlement hereunder. So the buyer buys a property that has this waiver. They cannot move in. The county will not give them a waiver also. So that problem has to be corrected. So this is a one-page disclosure form. If there's septic in a property, make sure you ask the seller whether or not they have gotten a waiver. Okay. And that can be gravity feed systems, or it can be these new alternative systems. Any questions about those forms? Okay. there's one more form that just be familiar with, and that is the sale of disclosure of lead-based paint. I was trying to keep this with only our state requirements here in Virginia and the forms here in Virginia, but make sure that if the lead-based paint disclosure form is required, that you have it as part of your contract. Okay. So that are the forms and the disclosure requirements in Virginia. Any questions about it? Any other questions you wanted to ask today? This is an Ask Larry session also.
Larry, I do have a request for you. Can you explain to everybody in reference to the contract, when you put the name of a title company, that there are 10 days that they can come back to you, but that it is the buyer, the one that has to contact the title company. I just want the agents to understand, because they think that once they write the name, everything is done. And then at the end, we have two title companies fighting. And I mean, it's very disturbing, and everybody does the work.
Okay, and this is the importance to understand. This contract form is between buyer and seller. It's not agent and agent, okay? It's not what we want or what we want to do. So paragraph 4 of the sales contract says that the buyer designates settlement agent. Buyer agrees to contact settlement agent within 10 days of date of ratification to schedule settlement. Settlement agent shall order the title exam and survey if required. Buyer has to make the contact. If the agent does, and the buyer decides that's not who they want to use, they don't have to use them. And now people have already done this other work. So when the contract comes in, we have to make sure the buyer's actually said, that's who I want. Because in the state of Virginia, the buyer has the right to choose who the title company will be, okay? And that right cannot be waived or varied, even by agreement. So the person they write in the contract is who they intend to use at this point, but until they actually contact them, they could change their mind within the first 10 days, because it says they will contact the title company within 10 days. So don't automatically start stuff for your party. We had a case several years ago at the Tyson's office where the buyer's agent was being very, very proficient, and the buyer's agent ordered the termite report for the purchaser. Okay. And it came back and showed everything was all right, but the purchaser ordered their own termite that came back and showed there was a problem. And now the seller's saying, no, you already ordered your termite because the agent did it. But the contract says the buyer will do it. So if you're going to be doing this stuff on behalf of your clients, you better have something in writing giving you power of attorney to do this stuff on their behalf. This contract is between buyer and seller. And when it says buyer will do something, seller will do something, that doesn't mean the agent does it. That means the agent gets in touch with their people and makes sure that they have done what they want. Okay. So, I'm sure that this will get worked out somehow or another, but at the same time, you shouldn't be doing their job. You should be seeing that it is done, because we occasionally get instances like this. Okay?
Larry, but my question is, what happens if after the 10th day, nobody says anything? One of the title companies keeps doing the work, and the buyer, through the agent, not the buyer directly, sends all the information about their, who the lender is going to be, everything. Are they committed to that title company or no?
No, because the agent sent it. In my opinion, no. Not unless there's something in writing where the agent was told to do it. We don't have power of attorney to act on behalf of these people. Okay. Unless, you know, I just can't see anybody ordering something or doing something on somebody's behalf. Otherwise, I can go out and order all kinds of stuff on behalf of my client, you know, and it might not even be the party they wanted to use. So, you know, got to be careful about that. Okay. Any other questions about anything? Okay, so I think we're meeting again next week at 11.